First of all, thank you so much for coming. My name is Carmina Tessitore, and this is
Sylvia Rakowska.
and we are co-chairs of the Alternative Dispute Resolution section of the Connecticut Bar Association. Our section aims to bring awareness to how various types of dispute resolution, non-litigation options exist for all types of matters, including mediation, arbitration, negotiation, facilitation, and there's such an umbrella of that. Don Tutson, who is the chair of the Sports and Entertainment section, is on his way. He got stuck in traffic and he's very sorry, but he will join us momentarily. He will give you a little bit of information about the Sports and Entertainment Law section's goals. Please keep in mind that we would love to have you as members of the Connecticut Bar Association and the various sections that we have. I believe there are 23 sections, 25 sections.
50 sections?
Oh, 50. Oh boy, I was way off. So we have about 50 sections. We also have committees. The Young Lawyer section is very involved as well. Here today we have a membership application. We strongly recommend filling it out. Membership is free for all law students, so please feel free to fill it out. We have Bill Chapman, who's the Director of the Government and Community Relations Department at the Connecticut Bar Association, here with us. You can give him your membership application. He'll take it back to the office on Monday. We also have gift bags of goodies for you to take with you, so please feel free to take some home before you go. And
Just a couple other logistical things. Please grab some pizza as we go along so that we don't have to take it all home. So feel free to move around freely. And the only other thing that I want to mention thus far is our next ADR section meeting is on November 20th, and it will be here at the law school as well. So we welcome everyone to that, and we also have scholarships available for students as well.
okay, thank you. So with that, we're going to turn it over to our esteemed panelists.
That's us?
Gentlemen. So I think what we'll do is we'll have each party go down the line, name, title, where you work, what you do, and then we'll get into our substantive material. Rob, if you'd like to start.
Sure. My name is Robert Romano. I'm the General Counsel for RISE International. What we do is a bunch of things. We represent coaches in their contract negotiations, either on the NCAA level or at the professional level. Number two, we represent students when they get in trouble at the NCAA level, eligibility issues, that kind of stuff. I represent, internationally, we represent athletes, coaches, agents, whomever, in front of the Court of Arbitration for Sport or the BAT Tribunal. And the fourth thing we do is help advise and value players when it comes to baseball arbitration. That'll be coming around soon. So, and also, I teach here. Tyler's one of my students. I teach with Ms. Tessitore over there. We teach the sports law class here. I'm also the Director of Sports Management at Mercy College. I teach at St. John's University. I teach at Columbia University. I teach at Instituto Impreso in Spain and Instituto Superior de Rocha Económica in Spain also. So, and then I come home for the weekend. How's that?
Thanks, Rob. My name's Jack McDonald. I'm the Director of Athletics and Recreation here at Quinnipiac. Sort of thrilled to be invited to this today. And as you probably all know, I think we're all sports fans or fitness fans, whatever it might be. And the sports world has got significant legal issues that, whether it be HR issues at Title IX or NCAA compliance or all sorts of different things that my job deals with quite often. It's literally as of today, we've got something going on. So very, very exciting time, but when you're dealing with people, these kinds of things happen. So I look forward to answering any questions or giving you some stories about the wonderful world of NCAA athletics.
Paul? Good evening. My name's Paul Kelly. I'm a partner in the law firm of Jackson Lewis. I am the head of the collegiate and professional sports practice. Jackson Lewis is a firm of about 800 lawyers in 56 offices across the U.S. I'm the former executive director of the National Hockey League Players Association. I'm also the former executive director of an entity known as College Hockey, Inc., which represented the 60 Division I NCAA schools playing men's ice hockey. What I do in the world of professional sports is I represent a number of both colleges, universities, and professional sports teams and leagues. So, for example, in professional sports, we represent the PGA Tour, the LPGA, the New York Yankees, the San Francisco Giants, the Arizona Diamondbacks, the Washington Redskins, the Green Bay Packers, the Pittsburgh Penguins, the Philadelphia Flyers, the Phoenix Coyotes. So we have a number of professional teams that we represent, and we provide advice to the teams on negotiating contracts for coaches, general managers. We assist them in getting visas for foreign athletes, like hockey players, to come over from Russia or Sweden, the Czech Republic, to play in the United States. We represent the PGA and LPGA tours doing the same thing for golfers, not only golfers coming over to play on tour events here in the United States, but U.S. Citizen golfers going overseas to participate in sporting events over there. So we do a wide variety of things. We also do investigations for teams and leagues as they require it. On the college and university front, we primarily represent schools, and if requested by schools, we'll represent athletes and coaches in connection with NCAA enforcement investigations and infractions cases. So we represent a large number of schools across the U.S. on all manner of violations, recruiting violations, eligibility, amateurism issues, and the like. I've been involved in a number of kind of NCAA-related proceedings, as well as ADR, alternative dispute type issues at the professional sports level as well. So.
Thank you, gentlemen. So we hope that you received your packet of materials sent via email from the Bar Association. It's a fairly hefty packet. We'll try to get through as much of it as we can. So what we'd like to do now is start with salary arbitration in Major League Baseball. Okay. So you gentlemen, I'm sure, have had your share of experiences dealing with players, dealing with coaches in that arena. Do we want to talk about, firstly, what is salary arbitration? How do we get to that point? How are we valuing a player? And then how do you actually get before the arbitrator to argue your case? And whom are you going up against? I think would be helpful as well.
That's me. Tyler, you know this, right? You guys had to do a mock arbitration last semester, didn't you? Okay.
We don't pay salaries to college athletes.
Well, baseball is different. I mean, as you guys are probably aware, a baseball player, your first 3 years of your contract, you're under reserve, all right, which means that the team owns you. They own your contract. Between 3 and 6 years, you're under what they call limited reserve. You have a right to go before the arbitrator if you choose to. If you're not under contract, you have a right to go before the arbitrator. And after 6 years, you're considered a free agent, which means you can go out there and get paid what you deserve to be paid. I mean, put your talents out there to the highest bidder, and whoever wants to pay you, usually the Yankees or the Red Sox, they'll pay you what they feel you're worth. But during that period of time, from 3 to 6 years, you're under this limited reserve, where you have a right, if between that period of time, to, if you can't get a contract from the team, to go before an arbitrator, a panel of arbitrators actually. There's usually a panel of 3. So what happens is, about now, the end of the season's here, the agents try to work out a contract, for their player. If they can't and they choose to go through arbitration, they will put the team on notice. And how it works is it's done interesting, a little bit different, a lot different from the PA, from hockey. The player's agent or an attorney will value the player. The team will value the player. Those numbers the value is kept a secret. It goes to those numbers are given to the arbitrator, and at that time there's a hearing. And the attorney or the agent for the player tries to convince the arbitrators that the player's value is A. The team says that no, the value is only B. And then the arbitrator can only do one thing. He only can pick the higher number or the lower number. He can't split the difference. He can't try to mitigate it. He can't try to split the difference on it. So if the arbitrators feel he's worth $1 more than one value, they win. It shoots all the way up to the top value. If he feels valued $1 less, it shoots all the way to the low number. So it's an interesting way of doing it, which the reason being is it promotes, because it's so scary and because it's so risky, that it promotes settlement. It causes teams to settle and causes agents to settle before they actually go in front of the arbitrator, because it's so risky. So that's pretty much an agenda.
In hockey, it's a little bit different than in baseball. It's similar in the sense that when you come into the NHL as an entry-level player, you don't have any rights to salary arbitration for the first 3 years. You then, in your second contract, have certain, you're a restricted free agent, which with salary arbitration rights that kick in after a couple of years. And then eventually, it depends on your years of service in the league or your age. If you reach a certain age or you reach a certain number of games in the league, you become an unrestricted free agent and you don't have to worry about the salary arbitration system. In hockey, the way it works, if you're a restricted free agent and you come up for a contract and you don't like the offer that's been made to you by your club, but they still effectively own your rights because they can restrict your movement, you can petition for salary arbitration. What that means in hockey is that we don't do it where you pick one number or the other. We are, in our salary arbitrations, it's a single arbitrator, and the arbitrator can split the difference. In my experience, that's almost always what happens. And so what the actual mechanical process is that players usually know around the end of the season, between the end of the season in May, June, and the July free agency period, which players are going to file. You actually have to file for salary arbitration. Not only do the players have the right to request arbitration, but the clubs also have the right in hockey to request salary arbitration. But both sides prepare a brief, and what's contained in the briefs are what they call comparables, right? So if you're a defenseman playing for the Boston Bruins and you've been in the league for 5 years, they're going to look at how many minutes you've played, how many goals you've scored, how many assists you've had, how many penalty minutes you've had, or whatever, and they're going to try to find other players with comparable statistics to yours, and what are those players being paid. And obviously the NHL Players Association, which represents all players who go into salary arbitration, they're not represented by individual lawyers or agents. The Players Association represents all players in the league, 740 players who petition for salary arbitration. They're going to put the players on the high side, right, that they think are going to kick up your salary. And on the flip side, of course, the NHL, which represents all of the clubs when they go to salary arbitration, so it's basically the same group of people that are arguing all these cases, they're going to have the same set of comparables, but they're going to try to find those that pay less. And when you get to the actual hearing, what happens is these hearings tend to run a couple of hours, and they're usually held at a hotel in a conference room. Usually there's a salary arbitrator who sits at the end of the table. Along one side of the table are usually a lawyer or two representing the league and the team, and then there'll be a couple of representatives of the club, typically the general manager or the assistant general manager. On the other side of the table, you'll have the representative of the National Hockey League Players Association or a lawyer next to him. You'll usually have the agent for the player who will be seated there, and the player is often there. And what happens in these hearings is that both sides, working off of the briefs that they've already prepared, debate the issue. And of course what happens is these salary arbitration proceedings generate a lot of ill will. And the reason they generate a lot of ill will is that the general manager, which is trying to convince this arbitrator that the guy, isn't worth what he claims to be worth, they have to criticize the player. The guy, he's lazy, he came in overweight, his goals dropped off, he didn't, he wasn't hitting as hard, he was injured all the time, So they're negative. And they'll throw in a couple of nice things to say. And then similarly, you'll from the other side, you'll hear some stuff that generates tension. And what often happens after these salary arbitrations is the players are so unhappy with the process in hearing the criticisms, they'll take the deal that'll be the resolution by the arbitrator. But then the next chance they get, they're going to want to be traded from that team, or they're going to want to sign with another team when they have the first opportunity to do so. And in hockey, if one side comes in at $2.5 million and the other side comes in at $3 million per year, I got to tell you, 9 times out of 10, they just split the baby. And it was like, do we really have to go through this exercise and this tension and this criticism in order to get to where everybody knew we were going to get to anyway? So in my experience as a trial lawyer over many years, watching this unfold, it's a bit of a farce. But it keeps these disputes out of the courts, and in some instances, it's the only way you can get these things resolved, because both sides dig in and they just won't budge, and you actually need somebody to get them to the middle.
Just in the collegiate world, obviously, a full scholarship is a full scholarship. There's no negotiation. If you're in a full ride in any sport, that's it. So we have a little bit less as far as the athletes are concerned. But as far as the coaches are concerned, when it comes to salary negotiation, it's my job to make sure I have the most recent data of all the salaries of all the coaches in comparable divisions, Division I in our case, and comparable conferences, ECAC hockey or the Metro Atlantic League, so that when a coach does win a championship and he or she wants to increase their pay, or the Big East or the Big Ten are coming after our coach and we want to negotiate, I have the data ready, very similar to arbitration. So I have the data ready so that we know that if a coach is making $100,000 or whatever and they're getting $1 million from the Big East, well, we can't match that. But unfortunately, if someone comes in at 150 from another league, then we have a chance. Very similar, but my difference is, obviously, student athletes, scholarships limited, and coaches, it's my job to make sure that I have all the data of all the coaches so that we know my coaches and ask for an outlandish amount.
I mean, in our sport, in hockey, we use alternative dispute resolution procedures in all aspects of what we do. We don't want disputes to find their way into the courts. And so if there is a grievance of some kind, if a hockey player, for example, is suspended by his club for some element of misconduct or something, he, or more properly the association in his behalf, can file a grievance. And if a grievance is filed, that dispute gets resolved in the same manner by alternative dispute resolution mechanism. Typically, again, we in the NHL use a single arbitrator. We rarely use a panel of arbitrators, and both sides can debate and select an appropriate arbitrator. We have kind of a panel of people that we tend to rely upon. But so whether it's salary arbitration, grievance arbitration, the other thing that in the world of professional ice hockey is that if you're a certified player agent, right, you can't just represent NHL players unless you're a certified agent. You get certified by the Players Association in the National Hockey League. So you will not represent an NHL player unless you've been so certified. If there's a dispute between agents, and there are all the time, right? One guy steals a client from another guy, and they're like at each other's throats. Happens all the time. You, as a certified player agent in the National Hockey League, you can't sue that guy in a court down the street. You have to submit that dispute agent to a alternative dispute resolution mechanism, and we do the same thing we do with the grievances on behalf of players. We oftentimes arbitrate and try to resolve disputes between agents so that doesn't spill over into a public court.
Paul, my question is, how are the arbitrators chosen or selected? Are they chosen by the PA or by the league? Or what's the mechanism?
Yeah, so typically each side submits 3 names, I believe it is. I think they do it, you put 3 names in an envelope, and they put 3 names in an envelope, and then they put the 2 together. And if there's one person who appears on both lists, that's the person who it becomes the arbitrator for that particular dispute. If there are 2 people that overlap, then it doesn't really make a difference. The 2 sides talk about it and they pick one. If there are 3 different names in both envelopes, so there's no overlap, then you have to you go to a second round and you say, okay, now let's do 3 more names until you find one that's commonly accepted by both sides.
I'm going to take a moment to introduce myself to everybody. My name is Don Tutson, and I am so late, and I apologize profusely to the panelists and to the audience and everybody who helped organize. That my GPS took me to a different spot, so I do apologize. It seems like we're already up and running, clearly, with the panelists. 2 panelists I know very well. Hello, Paul.
Hi,
Kelly. Nice to see you. Thank you for coming. I'm sure you already did introductions, so I won't.
I just got here.
And, okay. Well, then let me help Professor Lou Kurlancic, the last of the panelists here to arrive. Lou is a professor of law at the University of Connecticut, He's the author of several books related to sports law, including recently legal issues in professional basketball and legal issues in professional baseball. He's authored numerous articles and chapters on wide ranges of topics from copyright to sports law. He's currently an arbitrator for FINRA, the Financial Industry Regulatory Authority, and has served as special master for the United States District Court of Connecticut. So from a perspective of someone who's done arbitration, Lou is actually a very good source. So Lou, and I'm sure you might have something you want to add to your bio.
No, I'm fine.
And Rob, nice to meet you in
Nice to
person,
see you.
actually, and Mr. McDonald, nice to meet you, Don Tutson. Thank you for coming, everyone. So I don't want to interrupt. Where did we leave off with the last question? I bet it was a good one.
We were discussing, Don, salary arbitrations and player arbitrations, how to get to the arbitrator, how to proceed with procedures, how to value the player, et cetera. So that's when we are in the agenda. And I apologize for the hefty pack of materials they received, and that we'll try to get through all of that immediately. But the next agenda item that we were going to be discussing was the basketball arena.
Excellent. Okay. Rob, would you like to
Yes.
jump in on that one?
We say basketball arena, you're talking international or U.S. or?
Perhaps we can focus just on collegiate, because we try to be here.
Okay.
And yes, and then we can open up to also player misconduct and how that gets addressed in the NCAA rules, et cetera.
You want to take that?
You mean basketball arena, you mean the facility itself or the arena of the world of basketball?
The umbrella of basketball and how that varies with respect to professional versus college, the NCAA rules, just sort of an overview for folks who don't understand the difference.
Well, that's a really great question, and I'll sort of relay to you an incident that Paul and I was just discussing down in the cafeteria a few minutes ago, the real world of what's happening. And then the basketball, clearly it's the NCAA's probably most revenue-producing sport with a $14 billion contract with CBS and TBS, and it's just, it generates.
That's all?
For now,
That's
that's
all?
all. But it generates so much revenue, so much exposure. The basketball bracket is probably one of the biggest events in all of sports. That's the good news. The bad news is there's a lot going on in basketball where, because of the significant amount of revenue and exposure, people start giving the sport a little bit more of a break. Vis-a-vis, sometimes academically, the basketball student athlete gets more of an academic break when they're accepted to college then, and I'm a track and field guy because I couldn't play basketball, but they get more than the track and the tennis and the swimming people. They all get accepted based on the admission standards, and sometimes in basketball and sometimes football, there's exceptions because of the potential revenue of these sports. For example, literally there's an incident going on nationally as we speak where student athletes that were coming out of a junior college in the Northeast were accepted and enrolled and were practicing at another college, and it turns out those two student athletes had a fraudulent transcript the transcript was written by the assistant coaches from that community college.
Oops.
And then it leaked to another student athlete of a major Division I college in this region, and literally as of last Saturday, it found its way to Quinnipiac. Okay, so now my job, the coach's job, is, okay, first off, whenever there's a problem, the first thing you do is, they always say the cover-up is worse than the crime, and it is so true. We then report it to our student athletes. The long and short that we report it to our university administration, right up the food chain to the president of the college. But from that point, there's a young student involved. And what happened was his transcript was written, and we had how do we compare it? We actually brought the transcript up from another student from that same community college, and we discovered that the athlete's transcript and the normal student, non-athlete's transcript were totally different. And so we go, uh-oh. And the immediate instant when this happens is, let's throw this kid the hell out of Quinnipiac. He cheated, he lied, and he gets thrown out. Well, it turns out that we met with the student athlete, and we discovered that he didn't even see the transcript. And I know on my high school days, if my guidance counselor gave me a transcript with an envelope in it and said, here, take that to Quinnipiac, you would. You probably never even opened it if it was sealed. And that's what happened. This coach gave him his transcript, take it to Quinnipiac, gave it to the admissions acted upon it, and so on and so forth. we'll come to find out that we had to verify what his grades really were, and they were actually, not by much, but they were actually much different and a tad better than the fraudulent transcript that was written by the assistant coach who has since been terminated. Long and short of this is that we have declared this athlete immediately ineligible from play. The season starts next Friday night against Yale. He cannot play, he cannot practice. But in addition to that, this kid was hoodwinked by criminal adults because they depended upon him. He has no parents. He lives with his grandmother, and he was totally despair. And the long and short of it, we have made an appeal to the NCAA to try to get this young student athlete the ability to maintain his scholarship, even though he couldn't play at Quinnipiac. The NCAA approved it, and that's where we are today. So in terms of the basketball arena, you know, and we fill up the arena, we have great teams, but because of the compromises that are made, you know, the junior college thing is, at least in the world of basketball and football, it's there because they can't get their grades out of high school. And some of us think maybe we shouldn't be taking junior college kids. If you can't make it, I have 4 sons, 3 went to college and 1 didn't. And I love my one that didn't as much as I love the 3 that did. So not going to college and not going to college is not a factor, and sometimes you sometimes just have to say no. So, but that's a real issue in the world of basketball, and I hope that sort of meets what this standard is. And we're about to possibly retain a law firm so that this kid can possibly, I don't know, say file a lawsuit against this college for fraudulently submitting a illegal and fraudulent transcript on his behalf, which frankly could ruin his life. So he might end up becoming more of the filing a lawsuit against them. But in terms of the full arena, I think that quickly we have NCAA governance going on about stipends and guaranteed scholarships and full meal plans and insurance, because Shabazz Napier said I go to bed hungry last April, and which is not true. But the media just ran with it. The NCAA ran with it, and so we have a lot going on in the NCAA. The NCAA is completely changing. In the next 5 years, we're going to see hopefully we might not even see an NCAA because of really basketball and football. Football is changing their playoffs. Basketball is changing the stipend rule. There's a lot going on. But I must tell you, in my world, and I'm not a lawyer like all you are or aspire to be, it's getting pretty complex.
Mr. McDonald, on that, from a practical standpoint, as you described the endeavor with the department, with the student, how long in time does that take, a number of weeks or days? And what sort of efforts would the athletic department undertake to look for help on the outside?
This all happened Saturday.
Okay.
I'm literally at a basketball function up at the National Basketball Hall of Fame on Saturday, and I'm sitting next to my president and a coach, and we're literally working the texting and the whole bit, and NCAA, and it was all literally, because we had to prepare a statement for the media that had to go out, and basically we said that the student athlete has immediately ineligible from practice and play, and the NCAA has given us a waiver to allow him to continue with the scholarship. So, but literally, we're only 48, 72 hours into this today.
Okay. So, Paul, if you got a call, hypothetically speaking, on something like that, and what would you, from a lawyer's standpoint, want the client athletic department to focus on in terms of looking at the NCAA rules and how to deal with an immediate response?
Yeah, so we actually do a fair number of these types of cases, not specific to this set of facts, but representing student athletes, collegiate student athletes, whose eligibility is called into question either because of academic reasons or because there's some claim of a recruiting violation or whatever. So typically we're representing the student athlete, but we're really doing it at the request of the college. So we'll come in, we'll talk extensively first with the athletic director, the coach of the team, the student athlete, usually the parents of the student athlete, whoever the recruiter of that, probably some assistant coach. And then once we understand the facts, we'll reach out to the NCAA and proactively talk to the NCAA about getting a waiver or convincing the NCAA that whatever ruling that they have made against this particular student athlete, is inappropriate or is it too harsh, and that the kid should be permitted to play. And we actually have one of our lawyers, a guy named Jeff Silver, spent 12 years as the director of amateurism and eligibility for the NCAA, and he is the foremost expert in the country on getting student athletes eligible. And so we get lots of calls for prized athletes in all different sports, and the coaches are unhappy because right now they're prohibited from playing. And so I usually dump these in Jeff's lap, and he's very good at it. I wanted to say I don't know anything about basketball. I even have a hard time kind of watching professional basketball. But I will tell you that I see your little note here on bringing cases, international basketball cases, before a tribunal. Hockey, we have something along these lines. I mean, we're an international sport. We have players in the NHL from all different countries. I think probably 12 or so different countries. What happens in hockey is, most of the countries out there in the world have their own professional leagues, right? There's an elite Swedish league, there's a Finnish league, there's a Russian league, there's a German league. There are, and they don't necessarily want to lose their star players. They want to keep them within their country. And so there's an agreement that's, first of all of the countries have associations, national associations, and all those national associations are part of something called the International Ice Hockey Federation. If you're a player from Sweden and you want to come and play in the National Hockey League, first of all, you have to get a waiver from your federation, your national organization, in order to come and play. In addition, if you're under contract to some Swedish hockey team, professional hockey team, we have an agreement that the NHL, the NHL Players Association, has signed with each of the federations around the world. And the way it works is that if we want an elite Swedish player to come and play for the New York Rangers, for example, we have to pay $200,000. We, the National Hockey League, have to pay $200,000 to that federation, Swedish federation. We don't pay it directly to them. We actually pay it to the International Ice Hockey Federation, and then they distribute the proceeds back to the Swedish Ice Hockey Federation. If there is a dispute, and there are disputes all the time, those disputes between the countries or between the leagues, the NHL and the Continental Hockey League in Russia, or between the NHL and the Swedish Elite League, those get arbitrated by the International Arbitration for Sport, or the panel for, I forget the formal name, but there is a panel out there someplace in Geneva, I think it is, that these disputes get submitted to. So in our sport, we use arbitrations at all different levels. We use them for disciplinary matters, we use them for grievances, we use them for salary issues, we use them for agents, and we use them on a much larger scale in terms of bringing players from around the world to play. So one quick story. When the NHL was in a lockout situation, many of the players went back to their respective countries and played in the professional leagues around the world. And in fact, many of the American and Canadian players went over and played in the Czech leagues and in the Finnish leagues and in the Russian leagues. And when the lockout ended, most of the players had out clauses. In other words, when they negotiated a contract to play for the team in the Czech Republic, they had an out clause that when the lockout is settled, I get to return back to the NHL and play. Well, what happened was the Continental Hockey League in Russia wanted to keep many of their elite Russian players. They had them for half a season, and they were drawing bigger crowds, and it was a great season for the Russians because they had Ovechkin and they had Malkin and they had all of the Datsuk, all the top guys were at home playing, and they didn't want to lose those guys. And they wanted to know whether or not they could keep or try to keep some of those players by showering them with huge contracts in dollars. And so the Continental Hockey League actually hired me and my firm to give them advice on the topic. And our advice to the Continental Hockey League was, look, you violate every principle of international cooperation within our sport if you do that. First of all, you will be interfering with the contract between, for example, the New Jersey Devils and Ilya Kovalchuk, right? He's under contract to them for the next couple of years. You stealing him away to play for your team in Russia, you've actually violated, you are subject to being sued by the New Jersey Devils. And in addition, you will violate the waiver rules which have been in place around the world for years. And, you know, what sanction can be brought to you? Well, remember, you've got the Olympics coming up. Remember, the Winter Olympics were just held in Russia. You know, if you steal these players from the National Hockey League, and you don't let Malkin go back and Datsuk go back, and you lure these guys away, I will tell you what will happen. The National Hockey League will withhold its NHL players from your prized Russian Olympics. And that's how they will get back at you. And at that point, the Continental Hockey League said, we're not going there. We're sending them back. I think President Putin had something to say about that topic. But, you know, so, you know, the point is that these disputes at a very high level do get resolved and don't find their ways into the courts. Sometimes they get resolved through negotiation. Many times they get resolved through ADR procedures.
Well, I think what you're talking about is you're talking about going to the Court of Arbitration for Sport in Switzerland, right?
In Switzerland.
Yeah, yeah. So basketball does it a little bit differently, though. They have basketball, the International Basketball Arena, FIBA. They have an internal arbitration program in place. It's called BAT, Basketball Arbitration Tribunal. So if there's ever a dispute, before it can go to the Court of Arbitration for Sport, there's the BAT tribunal, which will hear different disputes, FIBA-related disputes. If a player gets transferred illegally, if they're not paid, if an agent's not paid accordingly, you can bring that dispute to the BAT, and they can resolve it. And it's relatively quick. Usually it takes about, you have 10 days to submit your request for arbitration from the date of the dispute. They have 10 days to respond, and you usually have a response within 45 days after that.
And
So-
Rob, I think you outlined that pretty clearly in your
Yep.
materials, right?
Yes.
So if you didn't receive the emails today, make sure you leave us your email address so all of the updated materials, including Rob's material, will get to you.
What do you think hockey hasn't taken that road, if there's so many disputes?
Not exactly sure why, frankly.
Yeah,
Yeah.
interesting.
In arbitration, generally, as lawyers here in Connecticut, we don't tend to think of it through a sports context. So it's easy to kind of jump right into the sports without getting the context of how arbitration generally works for lawyers as we walk around here in our little practices in Connecticut. So I'm hoping Professor Kurlansik might give kind of an overview generally about how arbitration and alternative disputes work outside of the sports context to give us a
I'm going to talk about what I told you I was going to
Sure.
talk. Okay.
No, sure, absolutely.
Which is different than what you just presented to me.
He's arbitrating.
I get on his toes, see?
Okay, anyway, I'm going to talk about something of an overview about player discipline, okay? And I think that to understand the disciplinary situation of a professional athlete in a North American sports league, have to take a step back first and recognize that he is in a situation different than employees in a conventional industry. So if someone works for Aetna and he's discharged, he can go work for Travelers. Or if he leaves Aetna, he can go work for Travelers. Indeed, the fact that he can go to Travelers is something that his employer at Aetna is aware of. And that knowledge will have an effect on the way the Aetna employer treats him. Okay? But the professional athlete is in a significantly different posture, because when a commissioner suspends someone, what that is an industry-wide ban. And at least in the absence of another league, which we've had on occasion, but highly unlikely we're going to see one in the future, I think, okay? And that the existence of another league completely changes the landscape, okay, for the employer-employee, okay? But in the absence of that, he can't go to another team, he can't go to another employer outside the league. I mean, he's a basketball player, right? He can play in the NBA. And now the commissioners told him he cannot play in the NBA. So in other words, while the rest of us have the protection of the market, The athlete does not. In addition, and we can talk about this in further detail if you want later, but just quickly, he doesn't have the protection of the antitrust laws either. So if all of the law firms in Connecticut got together and agreed we're not going to hire an employee who has hit his wife, okay, that almost certainly would be a violation of the Sherman Act. Okay? All the employers can't get together. In fact, we could apply some nasty words to characterize that, like blacklist or boycott, you know. The upshot of that is, the practical upshot is, that the extent of the protection that the athlete has is a product of the union and the collective bargaining process. Okay? And the results of that differ among the leagues. You know, what are the extent of the permissible sanctions? What process has to be followed, including whether you can appeal, et cetera, et cetera. Some matters, though, pretty uniform. One of those is that gambling's for the commissioner. Okay? By which I mean that if there's a matter involving gambling, the commissioner has the exclusive authority to deal with it. The union cannot file a grievance on the part of the employee, of the player, etc. It's not serendipitous that the strongest union, the baseball players' union, has achieved the most protection for its members. And that means that in most situations, John Rocker, A-Rod, whatever, there's a significant circumscription of the authority of the commissioner. Okay? And that's most manifest in the process which says if he disciplines someone, the union, the player via the union, can bring a grievance, okay, can challenge that discipline. And the commissioner must have, quote, just cause, show, quote, just cause for the discipline. And that was the case with A-Rod, for example. Alex Rodriguez.
Who's he?
Right, yeah, we have two
No,
examples.
not Ray Rice, dramatically different in the National Football League. Okay? The National Football League, there's this personal conduct policy, and it's for the commissioner to discipline under it. He's not subject to a just cause constraint, and indeed, the appeal from his discipline goes to the commissioner or the designee of the commissioner. In the setup where there's a just cause constraint, such as in baseball, if the union and management are unable to settle the grievance informally, then the dispute goes to an independent, impartial arbiter who has been agreed on by the union and management. And he decides whether there is just cause for the discipline. And that just cause inquiry, okay, involves two related central questions. The first is, what sort of behavior warrants discipline? Is the conduct legitimately a concern of the employer? So if the commissioner of baseball, or the team for that matter, sanctions a player for drinking at a bar in the off-season, you know, that would not meet the test of just cause. It's no business of the team. You know. Or if there was a curfew violation and the team fined the player $200,000 for that, that would be excessive. Because the second question is what form and level of sanction are appropriate, okay? i.e., is the discipline excessive? And indeed, even in A-Rod's case, as overwhelming as the evidence was against him, okay, the arbitrator reduced the sanction. The commissioner suspended him for 211 games, and the arbitrator said no, 1 season, 2014, 262 games. As I said, there's a significant contrast between the baseball process, the baseball structure, right, and what goes on in the National Football League, where the commissioner is essentially unconstrained, right, where the appeal goes to the commissioner's designee. Now, in the case now with Rice, because Goodell had to testify, he couldn't also serve as the judge, essentially, right? And a year or two ago, because of the circumstances, he had to hand the matter off to Tagliabue, okay, rather than he sit. And Tagliabue rendered a decision which actually was critical of Goodell. Just a word about salary arbitration, because even though it has the same noun, it's significantly different than what I've been describing, what I call grievance arbitration. Of course, just cause is a very vague phrase, obviously, but over a long period of time, labor arbitrators, right, have given it meaning, have given it substance. And, for example, have articulated certain principles. One principle is the principle of progressive discipline, okay? That you can't fire someone for the first offense unless it's egregious, okay? And one characteristic of labor arbitration and labor arbitrators, which is contrast with commercial arbitrators, is that the labor arbitrator writes an opinion. Okay? And that's because he's part of this overall ongoing process of governance. Okay? He's telling you what just cause means. I don't want to overemphasize. There could be a disagreement between the union and management about the interpretation of some provision in the collective bargaining agreement, not just cause, okay? And it go to the arbitrator. And he's going to tell you, and this is a part of an ongoing process, because, for example, in the National Basketball Association a number of years ago, there was this melee in which the players went into the stands and, fought with the fans. And Commissioner Stern, was going to discipline them, and the issue came up, and he said, "This is just for me. This is like gambling, This is just for me, because the agreement says that behavior on the court is discipline for behavior on the court is for the commissioner alone." Okay. And the union said, no, you're interpreting this wrong, because this wasn't on the court, right? This was in the stands. Now, I must say, when I first heard that argument, I didn't give it much, credence. But then, when I saw the arguments by the union, it actually had some substance to it. They referred to other parts of the agreement, and ultimately, a federal district court judge said, the union's right. You know? This isn't on the court. But my point is, when they went into the next round of collective bargaining negotiations, the result was it was made clear that that behavior was going to be exclusively for the commissioner. I don't remember whether they redefined what on the court was or whether they said something like, anything in the arena, But my point is, see, this arbitrator, he's part of this ongoing process about the governance of the workplace. Mhm. Now, there, the arbitrator's essentially interpreting or applying an existing agreement. With salary arbitration, the arbitrator is determining one of the terms of the agreement, what the salary will be. Okay? And that's often called a form of interest arbitration. And in the public sector, often you have legislation with respect to public safety unions, police, firemen. The legislature says you can't strike. But here's what we're going to do. If you can't come to an agreement, then we're going to have interest arbitration. An arbitrator is going to determine. Okay. But usually, and this is the case in baseball as well, and if I understood Mr. Kelly correctly, it's not the case in hockey. The form of arbitration is called, in baseball, salary arbitration, is called final offer arbitration. And what that means is each side presents a number, and the arbitrator has to pick one of those numbers. You can't split it in the middle. No. Okay. And the whole idea is that you want to push the parties together, get them to resolve it, because they know that if they submit a really high, ridiculous number, he's not going to go with that number. And the whole, the idea is to facilitate settlement by them. Along the lines of something else Mr. Kelly said about the agreements between the international agreements between the National Hockey League and European leagues. The National Basketball Association has a similar agreement with FIBA. Okay? And of course, we're about transfer of players. And of course, we're aware, somewhat different kind of agreement, but we're aware of the agreement between Major League Baseball and the Japanese League, under which several players have moved from Japan to the United States. Stop me if you want.
I think you actually answered the question that I posed.
No, because I want to say something. No, I want to say something else about salary arbitration. Because salary arbitration fits in with that idea that the professional athlete is different from the employee in a more conventional industry. Okay? And here's why. Okay, you're working for Aetna, you can go negotiate with Travelers, or the Hartford, or Phoenix. But the athlete, he doesn't have all those choices, right? He's limited to one team or a set of teams in the league, right? All labor relations in Major League Baseball descend from an arbitration decision, the Messersmith arbitration. What happened in Messersmith? 3 times the union, well, I shouldn't say the union, 3 times players went to the Supreme Court and said, look at this whole structure of this reserve clause where I'm tied to one team forever, It's a violation of antitrust laws. And 3 times they were rejected. Not on the merits, but because in the first case, Justice Holmes said a long time ago that baseball wasn't in interstate commerce. But be that as it may, this is dramatic example of historical irony, all right? 3 times they went there, and they knocked on the door with tremendous resources, all devoted to it. Nope. Now, there's a guy named Messersmith who was a pitcher, Andy Messersmith, and Dave McNally. And the standard uniform player contract in baseball said that if the team and the player were unable, after their employment contract expired, unable to reach agreement on a new contract, there was something called the option clause. And the team could invoke the option clause, and the result of that was that the player would be bound to the team for another year at 90% of his prior salary. I don't remember what the exact percentage was, but it was around that. Okay. So that's what happened with Messersmith. He couldn't come to an agreement. Team invoked the option clause. Now a year passes. They can't come to agreement again, Messersmith and the team. Team says, we're invoking the option clause. Messersmith says, no, you can't do that. You can only use the option clause once. Now, I got to admit, everybody assumed that was wrong, because there was this whole assumption that you were bound to a team forever. So the union takes it to arbitration. What's the correct interpretation? And lo and behold, a very distinguished labor arbitrator, Peter Seitz, he decides in favor of Messersmith. Never sat on a baseball arbitration again. Okay? He decides in favor of Messersmith. So now where are you? They have blown up the system. Got more than they ever could have gotten from the Supreme Court, for that matter. Because the upshot of Messersmith is everybody's a free agent after 1 year of invocation of the option clause. So what's happened, in a sense, is really the union has given back to management, and they've set up a structure that says, here's your salary, first couple of years. Another couple of years, you become a free agent. When you're a free agent, you're like that traveler's employee, right? You can go negotiate with all the teams. You're not restricted. And then they said, we're going to put something else in the middle. We don't want the player to have no leverage like he has those first couple of years. So what we're going to do is we're going to put in this institution of salary arbitration, where an independent person sets the salary.
We have a question back here, Professor?
Yeah, I was interested, we've been talking a lot about arbitration, but I'm particularly in hockey and the NHL. What role does mediation play? Certainly there was some story about the league settling with the Players Association through a mediator. But I'm wondering, particularly on the grievance side and the agency side, is there an effort to, before you take it to an arbitrator, to get a neutral to bring the parties together, or once the negotiation breaks down, do you go right to arbitration?
A mediator was used in the closing weeks prior to the end of the lockout, just to try to get the sides talking. But no, we in our sport, we really haven't had a great deal of success with mediation. It usually goes straight to the arbitration process. One thing that the professor said is true in my experience, which is the moment that an arbitrator renders a salary arbitration or a grievance arbitration decision which is unfavorable to one side or the other, he will never again arbitrate another dispute, which is why in our system of salary arbitration, where you split the baby, they always split the baby, because then both sides are happy and unhappy, and they always get asked to come back.
Like a job security.
Right? If you sided closer to the league, the NHLPA will never approve you, and vice versa.
I'm not sure I understand what the context is you're asking when you say mediation versus arbitration. Are you talking about during the collective bargaining negotiations employing a mediator?
Well, I was actually thinking, I mean, that could be an example, but I actually was thinking more of grievance
Oh.
arbitration.
Well,
You know,
no.
where
Yeah, we
you try to get.
They wouldn't go to a mediator. They might try to settle it informally
Yeah,
between the union and management.
I think I would add that mediation would be pre-collective bargaining agreement, where that the parties set down, the terms of the agreement, like when's free agency, what the
Yeah.
salary is, so that when they're not getting along and just trying to get into the final stages of the collective bargaining agreement, like the football, basketball, maybe hockey, that everything's negotiated, mediated, especially when there's no agreement. And then finally, the outcome is the collective bargaining agreement. So then when there's any dispute between the parties, the mediation has already occurred. So there's just a limited issues to really arbitrate. So, and I mean, especially with football too, where.
Well,
we
the
have
reason I
lockout.
asked the question was because if you meant mediation in the context of the collective bargaining negotiations, there is no resort to arbitration.
Yeah.
You know, you either reach agreement or there's a strike or lockout, okay?
well, not as, I mean, you could, in theory, collective bargaining agreements incorporate arbitration provisions. Often they name specific arbitrators.
Oh, yeah,
And,
definitely.
in the same way, you could incorporate, prior to going to a binding arbitration decision, you could, as part of the collective bargaining process, say, we're gonna try to do this informally first through a mediator. If we can't resolve it, then it goes to arbitration. Sometimes it's even called med-arb. Now, sometimes it's the same mediator who then becomes the arbitrator. And, there's a debate about how appropriate that is, but anyway, it's just different. I'm just kind of curious, looking at other, ADR processes and how they might apply in the sports context.
There's no arbitration route to the resolution of the collective bargaining negotiation. Yes, you could employ a mediator, someone from the Federal Mediation Service, for example.
Right, so that was,
But if-
he was
but if-
getting, that using mediation comes into play when you're resolving, when you're trying to negotiate
Yeah.
an agreement, you need a third party.
Yeah,
Right.
and his job is to facilitate an agreement.
And I think I would add that.
That's not what an arbitrator's job is, at
No, I
least not in the
understand.
grievance
Completely different, yeah.
arbitration.
And I would add
Contact.
arbitration in sports, there's such a short timetable because players want to get paid, they want to, start working again. So I think the arbitration's the best way to get a quick resolution without going to the steps of mediation.
Right.
And I think it would take too long.
And for people who don't know, Doug Lilly, our immediate past chair of the sports entertainment section. Doug is also a certified player agent for football. So he's got some experience. And I'll take two questions at this point, then I'm going to ask the panel to keep moving forward.
Professor Kravitz was talking about how the Messer Smith case blew up economics of baseball. But in that case, there was the possibility of a players' union that could create structure again, as also exists in hockey. I wonder if you can talk a little about the NCAA, the Northwestern case and the O'Bannon case, and what you see as happening if the NCAA structure blows up through those cases where there isn't an employer and the possibility of a union easily representing all the business.
Can we hold that question to just the next segment? Because that's a perfect way to take us to the amateur portion of what we want to do. There was one hand back there?
Yeah, Paul said that you kind of pick names out of a hat, or you submit different names, but how you ensure fairness and impartiality, I guess, of the arbitrator, like in the NFL, I know you don't feel that, but in the NFL, if the arbitrator is appointed by the NFL.
I mean, again, they use, the panel of arbitrators are distinguished law professors, lawyers. I mean, I don't think we've ever had an issue of impartiality. I mean, these are a collection of people, any one of whom would be very skillful and probably very capable at resolving these disputes. It's just that, you know, as in any mediation or arbitration, each side's looking for any advantage they can get, and if you have somebody who you think is pro-plaintiff or pro-defendant, that's the person you try to, you know, steer the process towards. But, I mean, that's really never been an
But
issue.
it's like if you had two law firms, one of the law firms wouldn't appoint the judge, right? So the same is true as far as like the NFL. The NFL appoints their arbitrators.
No, but that's not the way it works in
The NHL, yeah. not
Yeah.
Yeah, I think in football, there's a panel of arbitrators, and, you know, it really depends on what stage of the arbitration. If it's between, you know, for instance, I think there's a panel of arbitrators, each side, if memory serves correctly, like the bargaining agreement, each side picks a list of arbitrators, and they go down the list, like who they don't want, and just how they start, whoever has the last pick, it ends up that being the arbitrator. So there's no, you know, we're gonna fight over it. It's basically striking out on the list, whoever remains, then becomes the arbitrator.
Rob Romano.
Yes.
Professor Clance had made an indication that even in baseball, there are now two separate kind of tracks that arbitration takes as we think about issues. There's the salary portion, and now what we have with the A-Rod situation is a new element to that. In your materials, you reference a contract that Tim Lincecum signed early on in his career. Even though he was doing very well, he's kind of locked into that
Yep.
structure. What would you have to do if you were looking at his contract next time out in terms of arbitration?
Well, there's really nothing you can do. That the contract was signed when he was under reserve. So that first 3 years he's in the league, he's under reserve as agreed upon by the union, Players Association, and the league. So there's really nothing you can do. It's only when he reaches that third year point, or that Super 2 point, there's a Super 2 kind of way around it, that he has a right to go before the salary arbitrator if he's not under contract. So, but during that first 3 years, you're under reserve, the same reserve clause from that Justice Holmes gave him back in 1922 under federal baseball. So, Lincecum couldn't have done anything except take the deal that was offered. Yes.
So it's interesting how people think that baseball has such a great player side for the union aspects of it, but early for the first couple of years, players, even if they're doing very well, can be really locked into what their compensation.
Yeah, and they are. They're under the reserve for that 3 years, but the union gave that back. You know, from the Messerschmitt arbitration, the union gave that back. They saw the reason behind it. I mean, everybody being a free agent every year will depress salaries across the board. A few players will make out, but for overall, the players will get, most of the players, their salaries will be depressed. So they didn't want to be everybody becoming a free agent all at once.
That structure is not unusual for unions in other areas, that there's a preference for, quote, seniority for the people who've been there longer rather than for the people who are just entering.
And it might be a sexy topic also than what we've seen here with Alex Rodriguez. And maybe you all can help me understand, which I don't understand, how Alex Rodriguez last year, almost to the day, walked out as part of what would have been an evidentiary proceeding, and subsequently lost a year afterward, after the arbitrator came out and said, "You're out for a year." What would have happened in that arena if he went in and actually gave testimony or presented his case to the panel for baseball?
The arbitrator wouldn't have believed him. The arbitrator regarded the evidence as overwhelming, and indeed his walking out might have been a way to avoid testifying under oath, because although he denied for a long time, he never denied it under oath.
And that venue would have been, it would have subject him to being under oath even in that arbitration.
Oh, yes, absolutely.
portion of that hearing, right?
But my question is, and Professor, maybe you can help me out on this. I mean, the arbitrator is bound to the terms and conditions of the existing agreement, right? That
Yeah.
collective bargaining agreement, that joint drug agreement within the collective bargaining agreement. Alex Rodriguez was suspended for 161 games, but under the joint drug agreement, it says first offense 50, second offense 100, third offense lifetime ban. Where did the arbitrator? How can the arbitrator go outside of the existing agreement? I mean,
Yeah.
that's
Yeah.
always been my question.
Yeah, he didn't go outside the existing agreement. Both the union and management agreed that Rodriguez's case didn't come within the, if you're tested once, this is what happens. That a case where you had multiple usage over a long period of time of a large number of drugs did not come within
The
that.
50, 100.
Right, didn't come within, they said that was really about being tested once and show positive. I forget the exact numbers of, I'm sorry, the exact letters and numbers of the section of collective bargaining agreement, but they all agreed on that.
Beforehand, so that they gave the
They
authority of
didn't,
the.
no, they didn't, no, there is a provision in the drug agreement that he was acting
Outside.
under, but it wasn't that one. And they all agreed that that was appropriate. So then he was faced with the question of, well, what's the appropriate sanction?
Yeah, he has the authority to give any number he wants, what he feels, the arbitrator feels is appropriate, based on
Yeah.
that authority given to him.
And he actually referred to the 50, the 100, 150 in, coming up with his conclusion.
And I think, and maybe I misheard this yesterday, that Mr. Rodriguez admitted to DEA agents earlier this year that he had actually taken steroids when so basically he was admitting under oath in front of the DEA agents, and he would have been, if he showed up at the arbitration and said something different, he would have been subject to.
I don't know if he admitted under oath, but he was engaged in a process to avoid being put on the stand where he would have to testify in this trial of his cousin. And so he made a deal with them, and he got immunity, and therefore it's not clear whether he's going to testify, but.
And I guess from another, lawyers and aspiring lawyers, in a situation, Paul Kelly, when you have a witness, a client, who you're not quite sure how it's going to go with what that person has to say as to the veracity in a position like this, what is the take strategically as you want your client to come out in the best light?
Well, again, I'm a white-collar lawyer and a former federal prosecutor, and most of my career has been spent dealing with these very issues. I mean, no competent defense lawyer puts a client on the stand in his own defense if you have any doubt whatsoever about his ability not only to tell an effective, credible story, but to withstand a withering cross-examination. You're always worse off to do that.
Governor Rowland.
What we used to do as a federal prosecutor, prosecuting cases, whether murder cases, public corruption cases, I mean, what we used to do with witnesses that were shaky when we talked to them in our conference room or in our office is we used to wait till the court closed for the day at 4 or 5 o'clock. We'd get the key from the clerk, and that night at 6 or 7 o'clock, we'd go into the courtroom, we'd flip on the lights, we'd put the witness in the actual witness box that he or she were going to be sitting in the next day or the following Monday. We'd put a couple of interns in the jury box, and we would take that witness through a dry run, and then we would critique the person, and we would hear from the people in the jury box, should we put this person on the stand based on that performance or that second performance? What do you think? Do we put them on? Do we not put them on? And we did it frequently, and if we had any doubts, we didn't put them on.
Any questions on this portion of our conversation? And I didn't get to introduce myself earlier officially. My name is Don Hudson. I'm chair of the Sports Entertainment Law section of the Bar Association. I thank you all for coming. There are a lot of familiar faces here, a lot of friends. Lawyers in the room? Excellent. Law students? Excellent. UConn and Quinnipiac, I hope, and a smattering of others? Great. And I would tell my law students in particular that one of the things you're going to notice as you endeavor in sports entertainment practices is that it's a very unique area. So thank you for your work and the section, the alternative dispute section, because without your help, none of this would have happened. So I really do
And
appreciate it.
Sylvia also was a team
Sylvia,
effort
thank
on all fronts. Both those sections are very exciting. I know that we're running short on time.
Okay, exactly, I see that. We're going to jump in, and we had an audience member who's going to get us right to the next hot topic, which is amateur sports. What's your name, sir? I'm sorry. Great. And can you ask that, we're gonna ask your generic question again and jump right into it.
Ask the same question I said before. There was a discussion before about how the West Smith case blew up the economic structure of baseball, but having been blown up, as you pointed out, there was a structure, collective bargaining between a union and an employer, where they could reconstruct something. If the NCAA blows up because either the players are ruled to be employees or, I don't remember what the argument of the Urbana case is, then what will happen?
The limiting the amount of the scholarship is essentially price fixing in the labor market.
So then what, if the status of student athletes changes that radically and the entitlement to negotiate for compensation sort of changes, how do you put that genie back in?
Yeah, Mr. McDonald, I think that would be a great question for you, just to give your overall perspective. 20 years doing this, it's working for student athletes under a certain way to do it. We're talking about some radical changes. So from an athletic department standpoint.
Well, I think first and foremost, most of us in this room tonight, we're talking about professional athletes, basketball, hockey, football. I have 21
That's
sports.
essentially what Ed O'Bannon's argument was he was a professional.
Yeah, so what's happening here, what's good for the goose and good for the gander, that really shouldn't be what's happening, because you've got some student athletes in track and tennis and golf that, they're gonna get really impacted by this, probably the fact that their sports are gonna disappear. They'll be no longer sponsored, just so we can pay football and basketball players whatever we have to pay them. So as you can tell by my tone, we're really not in favor of this. I think it's really been a pretty good operation. It's been going along just fine. There's a lot of things we have to tighten up on our end, but, this money will be taxable if it goes that far. They'll become employees, and you lawyers will know a lot more about that than I do. But I can tell you right now that we are really nervous that, all of this topics tonight has been about men's basketball, football, and hockey. We have a lot of women and a lot of non-revenue sports that this is just going to basically destroy the operation as we know it. So we're really concerned. The new NCAA governance that's now embarking clearly is going to try to address some of that, so that maybe if Alabama wants to give something so maybe Quinnipiac doesn't have to do it, so that's okay. But as I said at a meeting yesterday, we had a National College Hockey Summit up in Springfield yesterday. You can't legislate facilities, you can't legislate salaries. Ohio State's going to have a $150 million budget, and Central Connecticut's going to have, $10 million budget, and that's not legislated. So I think that, Ohio State's great, and Big Ten's great, and our student athletes love to play them, whether they get the stipends or not. So I'm just nervous about it. I don't think change is bad, but this involves all the sports in both genders. In all of the topics, even tonight, we find ourselves falling into, men's revenue sports. So I hope we crawl before we run here. There's a long, long way to go. And maybe the Super 5 conferences is probably a good way to start, because they don't have consensus as to what they want to do. I was with the former athletic director at Boston College today, and there's no way Boston College, Wake Forest, and Northwestern can keep up with Alabama and Texas and Ohio State. There's just no way. And so they're in more trouble than really Quinnipiac and Fairfield are. So I don't know if I'm answering your question, but my statement is this is more than just about 3 sports.
Yeah,
two sports.
I wasn't even asking about whether it would be a good development or a bad development. I'm assuming that there's some probability it's going to happen, and asking for speculation about what the consequences are.
Yeah, I think legally, that's the same thing for the lawyers. What all of a sudden you are giving them a stipend of some sport, or some sort. What labor laws kick in? I really wouldn't know the answer to that.
I'd be surprised if you saw the NCAA become extinct. I mean, because the alternative is the role that the NCAA plays, to try to keep and create a level playing field and make sure that there's not recruiting violations and that you're not bringing in people who aren't academically eligible, and the whole notion that sport is part of the whole educational process. If the NCAA is not doing that work, then it's going to fall to the conferences, and it's going to fall to the individual schools, which costs probably a lot more money than it's going to cost now. So even though there's radical upheaval coming, you're not going to, I don't think you're going to obliterate the NCAA. You know, with respect to the Northwestern case, and whether or not student athletes are employees as opposed to students, I mean, my understanding, based upon pretty good information, is that regardless of what the NLRB does and make whatever their decision is, that the student athletes on the Northwestern football team are going to vote that union down by a large margin. They're not going to want the union. And if you are an employee and you're receiving a full scholarship to play football, I mean, it creates all kinds of issues, tax issues, Title IX issues. I mean, just an array of, you know, Fair Labor Standards Act issues. Are you being paid the right hourly rate? I mean, just, it would be a dreadful legal scenario, and I don't think that ultimately will come to pass. The O'Bannon lawsuit, you know, the NCAA is going to fight that tooth and nail. They've appealed it. Frankly, the decision wasn't horrible for them, right? It could have been a hell of a lot worse than it was. The judge threw a few bones in the direction of the NCAA, but notwithstanding, they are going to appeal it, and who knows how that's going to come out. Nobody at this point knows, but, you know, look, are student athletes entitled to be paid if they're bringing in millions of dollars to their universities based upon their image rights, their skills and ability learned over 18, 20 years of hard work in their lives? Should they be entitled to whatever, lifetime medical payments, the ability to come back in 4 or 5 or 10 or 20 years and get a degree if they leave early, some money, you know, for the fact that their pictures being used on video games and the like? I think they should be receiving all of that stuff. And that shouldn't cause a complete upheaval of intercollegiate athletics. It's going to change it, but I don't think it's a death knell.
The O'Bannon case is probably going to pass, and what concerns me the most is the fact that they're using the likeness of uniforms in video games. What about television? We have a $14 billion contract, and you get Shabazz Napier on TV for 40 minutes every game, and he's going to bed hungry at night. So that's going to be really, it's going to blow it up.
It's a $64,000 question, okay?
What a $14 billion question.
Yeah.
First, I think in
As
the
was, I'm sorry.
I was gonna say, in the O'Bannon case, it was use of his image after he left. He wasn't in school, that was really the issue. But
Two different cases.
how do you avoid, even if they're not employees, if they get a stipend, they get something, some sort of money that's separate from a scholarship, how do you avoid an antitrust violation? If the NCAA says, oh, okay, you can give them $5,000 a year for whatever, stipend. And then Alabama says, well, you know, we want to give 10,000, we want to give 15,000, you know. Or the student says, look, I don't, you know, I'm stuck with $5,000 here because all these schools are conspiring to limit my stipend to $5,000.
Yeah, absolutely.
Well, they're conspiring now.
That's what the judge was scared of. That's what, because once you go the antitrust route, as they're going, it's very hard to reach a conclusion short of the market should decide it. That's what the antitrust laws are all about, actually, right? So you have the judge, and she decides, and you should make clear, there were two separate suits. There was the Keller suit, which had to do with the video games and the right of publicity. O'Bannon had to do with limiting the amount of quote payment of the amount they received, and so she decides it, and she kind of goes the straight antitrust analysis. You know, what's going on here? You know, they're getting together and they're agreeing. You know, how much they're going to offer them, and then when she gets to the end, and she's like, "Well, you know, I don't like where this is going." Right? So she starts coming up with, well, you could give them $5,000. You could put a trust fund into it. You know. I don't know. Now, remember, as Mr. Kelly also was suggesting, both of these are on appeal. We don't know what's going to happen with the National Labor Relations. I'm wondering whether he had some inside information about that vote, because, the vote was sealed of the Northwestern football players, and not to be opened until the NLRB made its decision, if it made its decision in a certain way. It's a mess. It's a mess, and I think that...
That's why we need arbitration.
No, and I think they brought some of it on themselves. And I think kind of an interesting political science question is, what do the conditions have to be for the NCAA to change, along the way? Because, look, they're illegitimate in a certain way. They are making rules that affect people dramatically, and those people have no say in the formulation and implementation of the rules. That's why the union thinks going, or started up. Actually, I think a union, as you implied, if you really could have a union that worked, then you might be able to resolve things. Because here's the thing, and I didn't say this before. I said that the athlete doesn't have the protection of antitrust laws. Okay, here's why. Because, and this is very relevant to, hey, the union's there, and now maybe we can work things out. And that is, there's something called the non-statutory labor exemption from antitrust. And what it means is, we have these two bodies of law, and they really, each of them has a different directive, organizing principle, okay? The labor law says you should, by agreement, determine, right, what the working rules are. And you have antitrust laws which say, no, the market should determine, all right? So, because you didn't want to have a schizoid system, the Supreme Court had to come, the federal courts had to come to some notion of what's a proper accommodation between these two bodies of law. And they basically said was, if you agree to something in the collective bargaining agreement, then it's immune from scrutiny under the antitrust law. So like in baseball, the union's there, okay, and they work things out. You can't attack it under the antitrust laws, what they agreed to. But I don't know.
Until you reach impasse.
Can I go back to the NCAA for a minute? I mean, Jack and I were talking about this earlier this afternoon. I represent Joe Paterno's wife, Sue Paterno, and her family, and the former coaches and players at Penn State University. And on behalf of all those people, we have sued the NCAA. I'm not a big fan of the NCAA's. I think the NCAA has some ridiculous rules, and their implementation of those rules has been inconsistent and unreasonable in many areas. And just to talk about the Penn State case for a minute, I mean, in that case, they have this thick rule book, right? I happen to have a copy of it with me, that's hundreds and hundreds of pages long, that has all kinds of detailed rules and regulations about when there's a violation or...
Smaller than that.
But if you remember what happened in Penn State, right? They just abandoned the rules. They said, the hell with the rules, right? We have all these procedures for investigation and enforcement and appeals and the whole works, and what Jerry Sandusky did was so horrible. Forget about the rules, and we're just going to summarily enter this consent decree, $60 million, no scholarships for umpty-bump years, and no postseason play, and you lose all these wins for the last umpteen years. And they just ignored what was in here. And you just can't do that. And so what we've said in the lawsuit is, look, what went on there at Penn State University was criminal conduct. Somebody running around sexually abusing young boys, or the cover-up of that criminal conduct by others. What business of that is of the NCAA? They had no business. They had no authority, they had no jurisdiction, and they shouldn't have got involved at all. And once they decided to get involved, if they were going to get involved, they had to follow this, right? It's the Constitution and bylaws. It's what the membership signs up for. It's what you pay. Quinnipiac pays every year it goes both ways. And they can't just abandon it. And so we're challenging the NCAA, and actually we're ahead on points if you read the papers. We're actually, I think, going to ultimately prevail.
What
And
remedy are you seeking?
we're seeking, we want a judge to declare the consent decree that was imposed against Penn State void as being beyond the authority and jurisdiction of the NCAA, and to remove all the sanctions and to return the monies that have been paid as an effort to not only rehabilitate the reputation and good name of the community at Penn State University, but of Coach Joe Paterno, who was, I think, and you can differ, but based on the facts as I know them, unfairly besmirched in the course of that whole matter.
And Paul, I think what I'll do is I'll collect emails from people here, so anything you send that you would like to follow up, I'll send out as well. And I would like to maybe continue down the line so people can get their last thoughts and offerings here as we wind up. Mr. McDonald, I don't know if you want to wind up.
I'll just follow what Paul said. The reason why we have all this governance baloney going on in the NCAA, frankly, you know, we're in sports and we're used to saying we need to fire the coach. We need to fire our director of the NCAA. He is terrible.
From UConn.
Because
film on that too. So
we have the stipend rule because of some players at Ohio State were selling their trophies to make tattoos, so that, and then we have he just came out 2 weeks ago saying that we got to do something about signatures because of Jameis Winston, and he's not saying stuff before these happen, he's saying them after. So I really just think that the leadership is awful. The rules are implemented by us, but he comes up with these half-baked ideas after there's a problem. And that's why we have this governance change.
Well, as lawyers, we thank you for your frank and honesty. No, seriously, that's you really hear that sort of honesty. And in lawyers, you have to learn how to collect that and know what to do with it, as Paul indicated. So, Attorney Romano.
Yes.
You have some concluding remarks that you'd like to offer?
Well, I'd like to second the vote on Mark Emmert, the head of the NCAA. I mean, I think you're right. I mean, he's not showing leadership at all. No. He's after the fact on many issues. He doesn't tell the conferences or doesn't implement rules. He tells them, gives them the power to do it.
Yeah, he listens to the media more than the membership, is what I say.
You know he was a UConn.
Yeah, that's the problem.
For sure.
Maybe we should end there. We're running it.
I think at its core, okay, there's an unnatural athletic academic connection in the United States that exists in no other country. In order to get pre-professional training in basketball or football, we say, go to college. Can you imagine a kid in England who says, I want to be the best soccer player ever, and then you say to him, go to Oxford?
It's true. Yeah. But yeah, their system's a club system in Europe for the most part, where they work up through the club system up to the professionals.
It's inevitable you're going to have challenge to the academic, among other things, challenge to the academic integrity of the institution as a result.
And we will be here, monitoring this every semester. So check in with us as the Connecticut Sports Entertainment section. Again, you'll have connections with everybody here. We'll be able to follow up. And I do thank everybody here on the panel, Attorney Kelly, Mr. McDonald, Attorney Romano, Professor Kurlancic, and again to Quinnipiac for hosting us. Thank you all for coming.
Beautiful. Good. Great.